Welcome to the ISMM Level 4 Unit 401, and that is Managing Responsible Selling. Very much this unit is all about how individuals and organisations meet the social and ethical requirements. And in terms of credits, this is a 4-credit unit, guided learning hours, around about 35 hours. So, why even have a unit that is based around this subject? Well, when you think of the word sales or selling, what comes to mind? Well, for you, if you're in the world of sales, it may be slightly different to what comes to mind for people outside the world of selling. When people outside the world of selling are asked what comes to mind, very much this is the word cloud. We're seen as pushy. We're seen as difficult, dishonest, sleazy even. These are words that obviously don't feel good when you're in the profession of sales. So what I love about the ISMM is they're very much trying to bring sales as a profession across to the UK. Why is it that as a salesperson we don't need qualifications to be able to actually sell? So it's a shame that words like this come across. So this unit is very much all about making sure that your organisation doesn't fall into the trap of being targeted with words like this. Because when we think about sales, does that come to mind? Now, there's nothing wrong with certain trades that we sell. You know, my background, I've sold double glazing, I've sold door-to-door products, but very much if we're coming across like this individual, we're not doing our job properly. Why is it that when people go into the Apple store, we don't think about them as salespeople? Whenever I ask people, how would you describe an individual in an Apple store that comes up to you and tries to sell something? They never describe them as salespeople. They always describe them as geniuses or geeks or customer service agents. Well, do you know what? They're salespeople. They have a product there and they're there to sell. But the reason why maybe they don't come across as salespeople is because they tend to advise people. They give people advice. They tend to give them recommendations of what they should use, as opposed to this individual here who's maybe trying to sell them something. So these are the learning outcomes of the whole unit. Learning outcome 1 is to know the legal, regulatory, ethical, social requirements pertaining to the sales function. Number 2, understand how to manage the sales function in a way that complies with legislation. And number 3, know how to deal with non-compliance. Today, we're going to take a look at knowing the legal, regulatory, ethical and social requirements pertaining to the sales function, i.e. learning outcome 1. And this is the area that we cover. There are 4 main parts to learning outcome 1. Explaining what the requirements are and codes of practice, understanding the principle of contract law and the penalties for misrepresentation, analysing potential impact of social and ethical concerns relating to us in the sales department, and lastly, how processes and policies in the organisation meet those requirements and comply with legal and regulatory requirements. So let's take a look at Learning Outcome 1.1, which is explaining sales-related legal and regulatory requirements and code of practice. Now, there are a number of legal and regulatory requirements which apply to the sales function within an organisation that will impact on us as salespeople. They mainly exist to give protection to the consumer, and they impact on areas such as contracts, terms and conditions, trade descriptions and standards, data protection and privacy, financing, product labelling, packaging, returns, refunds, and warranty. So let's take a look at the first one, which is Sales of Goods Act 1979. Now, when a purchaser buys goods, they enter into a contract with the seller of those goods. There are strict sets of rules that retailers and sellers must abide by, and these are detailed in the Sales of Goods Act. The next one, Consumer Protection Act 1987. The main aim of this act is to help safeguard the consumer from products that do not reach a reasonable level of safety. So it's in there really to protect us as the consumer against products which could potentially be unsafe and harmful. The third one, Consumer Credit Act of 1974. quite simply, this relates to credit card purchases, but also gives the customer protection when they enter into a loan or hire agreement. Next one, Data Protection Act, 1998. This is a law designed to protect personal data stored on computers or in an organisation's paper filing system. It also gives legal right to people who have information stored about them. Sunday Trading Act. The Sunday Trading Act governs the right of shops in England and Wales to trade on a Sunday. Various rules around that. We'll cover that in some more detail in a moment. Consumer protection from unfair trading regulations. This provides consumer protection from unfair or misleading trading practices. For example, misleading omissions or aggressive sales tactics. Financial Conduct Authority. If your business is involved in consumer credit, you will need to be aware that you must be regulated by the FCA, the Financial Conduct Authority. General Product Safety Regulations 2005. This very much covers specific types of goods and safety standards that they must comply with. They include technical and legal requirements for safety, design, packaging and insurance, and it ensures that products are safe and fit for purpose. And the last one on here is Unfair Contract Terms Act 1977. The Unfair Contract Terms Act regulates contracts by restricting the legality and operation of some contract terms. The law considers some contract terms to be unfair if they give the trader an unfair advantage over the consumer, or if they attempt to take away other legal rights. The Act extends to nearly all forms of contract, and in particular, it limits the applicability of disclaimers of liability. So let's take a brief look at each one in turn to highlight some of the main provisions which you would need to be aware of. So let's first of all take a look at the Sales of Goods Act. The Sales of Goods Act is very much as described. It's what we call the Ronseal effect. Are you selling goods exactly as it says on the tin? So very much the first area is it as described? And that refers to any advert or verbal description made by the seller. Goods must also match any sample which the customer has been shown in store and any description, for example, in a brochure. So does it do exactly what it says on the tin? The second part is the quality satisfactory? So this covers minor and cosmetic defects as well as substantial problems that we may have. The Act doesn't give you any rights if the fault or defect was pointed out or was obvious at the time of sale. So very much if it was bought as seen and clearly it had that defect when you bought it and it was pointed out by the seller, well then that doesn't count towards this. And lastly, the third area of the Sales of Goods Act is it fit for purpose? This means both the everyday purpose and also any specific purpose that is agreed between you and the seller. So for example, if the customer has specifically asked for a printer which is compatible with their PC, but actually the product you sold them isn't compatible with the PC, this would be contrary to the Sales of Goods Act. So one of the questions to think about is how does your organisation monitor whether or not it complies with the requirements from the Sales of Goods Act? So let's take a look at another of the acts, and this is the Unfair Contract Terms Act 1977. And the three areas really here is, does it give the trader an unfair advantage? Does it limit the customer's rights? And are there any exclusions within this? As I said before, the Unfair Contract Term Act regulates contracts by restricting the legality and operation of some contract terms. The law considers some contract terms to be unfair if they give the trader an unfair advantage over the customer or they attempt to take away legal rights. So very much if it gives that unfair advantage, it limits your rights, or there are certain exclusions that have been put in there, then absolutely that will be against the Unfair Contract Terms Act 1977. So let's talk about the Unfair Contract Terms 1977. The first area, does it limit the customer's rights? Well, contract terms which are unfair terms would include terms such as a term which tries to prevent a customer from carrying out their legal rights. For example, the right for a refund for faulty goods. Or a term which tries to prevent the customer from taking a trader to court. A term saying that the trader is not responsible for a death or injury caused by something that they have or haven't done. Or a term saying that the trader is not responsible for delays when clearly the delays were their fault. Secondly, does it give the trader an unfair advantage? Well, contract terms which would give them an unfair advantage would be any term which is very difficult to understand, perhaps because of the language or the print size. Any term saying that the trader is not responsible if they don't do what they should do under the contract. Or a term which tries to prevent the customer from keeping back payments when a customer has a genuine complaint about the goods or services. Or a term which tries to make the customer pay more than is needed to cover the trader's losses if the customer cancelled the contract. A term hidden from the customer until after they sign the contract. Sounds pretty devious. Or a term which gives the trader wide cancellation rates, but not giving the customer those same rights. A term giving the trader the right to change the contract to their benefit only. Or a term which makes it very difficult for the customer to end a contract. For example, a term making the customer pay high termination charges or giving a long period of notice. And then thirdly, let's talk about exclusions. So there are certain exclusions which exist. A term is not unfair if the customer has individually negotiated with the trader, or if the contract is between the customer and another private individual instead of a trader. A term also cannot be classed as unfair if it has to be included because of law. So, for example, if EU legislation or international conventions say that cannot be, for example, part of that contract. So my next point to you guys would be to say, have you checked your organisation's contracts with its customers? Are they unfair in the terms of this Act? Okay, so who can open for longer on a Sunday? Well, firstly, small shops, providing they are not over 280 square metres or 3,000 square feet. In addition, regardless of size, there are certain large shops which are exempt from the Act, and these will include things like airport shops, pharmacies, goods from exhibition stalls, farm shops that sell their own produce, including fishmongers, petrol stations, railway stations, motorway service stations. So a number of stores that can still open even though they're over that size of establishment. On to the Consumer Protection Act 1987. The aim of the Consumer Protection Act is to help safeguard the consumer from products that do not reach a reasonable level of safety. So let's take a look at three areas here. First of all, what do they define as a product? Well, a product means any goods or electricity. It covers any product contained in another product. So, for example, a raw material or a component of that product. That would be liable to the Consumer Protection Act 1987. Secondly, strict liability. This means the consumer doesn't need to prove that the person liable was negligent in any way. The consumer only needs to show that an injury or damage resulted from a defective product. And thirdly, exemptions from liability. There are certain instances where the seller will be exempt from liability. These include the following. The product was perfectly safe. Fair wear and tear caused the damage. The consumer had disregarded the instructions or warnings which led to the damage. The consumer had used the product in an unexpected way which resulted in that damage. The product was as safe as a person could genuinely be entitled to expect, taking into account its nature and presentation. Or the producer couldn't have been expected to know about the defect given the scientific and technical knowledge around at the time that the product was made. So quite a fair act, I think, sort of giving the producer certain rules and regulations and guidelines as to what they should and shouldn't be liable for. The General Product Safety Regulations Act of 2005. Let's take a look at this. Let's first of all take a look at the area of product. The regulations apply to products supplied commercially that are consumer products, or which are likely under reasonably foreseeable conditions to be used by consumers. They include products that are new, used, reconditioned, or made available for consumers for their own use during or providing a service. For example, chairs in a coffee shop. That would be under this part. The producer. So we'll look at this one down here. The producer. The regulations apply to all UK suppliers of products used by consumers, regardless of whether the products were intended for them or whether the products were intended for use in the UK or another EU member state. Safety requirements. The product under normal or reasonable foreseeable conditions of use should present no risk to the consumer or only minimal risk compatible with the product's use, and be consistent with a high level of protection for consumers. Basic duties. Well, basic duties, these are basic duties on manufacturers, distributors, retailers to put only safe products onto the market. Information and warnings. Producers must provide relevant information and warnings, for example, in terms of notices and labelling, to ensure that consumers can assess the inherent risks in a product throughout its normal period or foreseeable period of use. Criminal penalties. This is when it gets interesting. These are criminal penalties for breaches of these regulations, such as imprisonment for manslaughter caused by a dangerous product. Okay, let's discuss consumer protection from unfair trading regulations. These regulations provide the consumer protection from unfair or misleading trading practices, misleading omissions and aggressive sales tactics. Misleading and aggressive practices and sales tactics are assessed in light of the effect that they have or are likely to have on the average consumer. There is a blacklist of banned practices which are deemed to be unfair and therefore banned. Let's take a look at a few of these in more detail. So, misleading actions. Companies are not allowed to use misleading or underhand tactics to get customers to hand over their cash. Misleading actions include advertising goods that don't exist or offering just a few items at the advertised price without being able to meet the larger demand at that price. If an organisation has signed up to a code of practice, then if it fails to follow this code, it could be a breach of the consumer protection from unfair trading regulations. Organisations are banned from lying about goods or passing them off as another product to give them credibility. Misleading omissions. Well, sometimes it's not what's actually said that's the problem, it's what's been left out that causes the problem. The regulations offer protection against organisations who are economical with the truth or miss out key information which the customer might need to make an informed decision. Information should also be provided in a timely manner and not so late that it's of no use to the consumer. Aggressive sales tactics. Sales tactics can greatly influence a consumer's decision. Organisations who fail to take no for an answer, refuse to leave until a contract is signed, or use threatening behaviour will be committing an offence. For example, in an organisation which places extreme pressure on its salespeople to achieve their sales targets with a high commission, low pay structure, are kind of often in this area that could be guilty of this. So managers should take particular care to provide the appropriate support for their staff to avoid any unethical practices which are being adopted. A practice which is considered aggressive if the average consumer freedom of choice or conduct is significantly impaired. The legislation contains a list of criteria to help determine whether a commercial practice uses harassment, coercion, including physical force, or undue influence. Undue influence is categorised by something that applies pressure even without using or threatening to use physical force in a way which significantly limits the consumer's ability to make an informed decision. Banned practices. There are 31 specific practices that are banned. Here are just a few. Bait advertising, luring the consumer with attractive advertising around special prices when the trader knows that he or she cannot offer that product or only has a few in stock at that price. Bait and switch. Bait and switch is all about promoting one product with the intention of selling something else. Limited offers. Falsely stating that a product will only be available for a very limited time, or that it will only be available on particular terms for a very limited time, in order to elicit an immediate decision and deprive consumers of sufficient opportunity or time to make an informed choice. So it's if you don't decide today, then that offer is no longer available. That's deemed as unfair. False free offers, describing a product as free or without charge if the consumer has to pay anything other than the unavoidable cost of responding to the offer and collecting or paying for delivery of the item. Pressure selling, creating the impression that the consumer cannot leave the premises until the contract is formed. Aggressive doorstep selling. Aggressive doorstep selling is when conducting personal visits to the consumer's home, ignoring the consumer's request for them to leave or to not to return. And remedies. This is victims of misleading actions. So, let's put this to the test. Let's do a quiz. Let's imagine, what I'd like you to do is to think, which category do these fall into? Misleading omission, aggressive sales tactic, bad practice, or misleading action. So, there is an auto parts organisation, a dealer, and it says that they only fit genuine branded parts to your car, when in reality they're fitting non-branded parts. What do you think that would come under? Misleading action, because they're saying it's branded when they're not. The next one, contracts omit clauses on how to cancel or withdraw from that contract. Yeah, absolutely. Misleading omission, because they've left that out of the contract. Timeshare holiday presentation, which prevents the customer from leaving the meeting without signing a contract. I've been to one or two of these. Which do you think that is? That's bad practice. You cannot stop a customer from leaving. They are within their rights to walk out of the door without signing a contract. A door-to-door window salesperson visits a potential customer and states that if they do not sign the contract today, the offer has gone from the table. That's aggressive sales tactic. May have been okay 20 years ago when I was selling double glazing. It is not okay now, thank goodness. An advert saying a washing machine was £500 and is now sale for £250 when it was never on sale for £500. That's misleading action, because it was never on sale for that price. An additional service charge is not detailed in the contract. That's misleading omission, because it was deliberately left off. So, we've discovered some of the omissions, some of the bad practices, some of the misleading ways that salespeople can operate. Let's now take a look at Consumer Credit Act. So, let's start talking about the Consumer Credit Act. If your business includes financial arrangements, you will need to be aware of the Consumer Credit Act and the Financial Conduct Authority, the FCA. The Consumer Credit Act, this act regulates credit card purchases, but also gives the customer protection when they enter into a loan or hire agreement. The content and form of the credit agreements is covered. The method of calculating annual percentage rate, the APR, is within this. It also covers procedures relating to the events of default, termination or early settlement, credit advertising. Section 75, which gives you extra protection on terms costing over £100 and up to £30,000 paid by your credit card. It covers assessment of credit worthiness, so how organisations will assess whether you're credit worthy. Information to be communicated to the consumer. This talks about nature of agreement, parties, credit or credit limit amount, APR, repayments, duration of agreement. It also covers the withdrawal and cooling off periods. Let's now talk about the Financial Conduct Authority. So let's talk about the principles of contract law and the penalties for misrepresentation. We've looked in previous section about legal and regulatory requirements. It is also important to remember that when you are dealing with sales and customers, the ultimate aim is for you and the customer to make a contract for the services or a product between both parties. If you're in this position, you need to understand what constitutes a valid contract and whether a contract has actually agreed to your product or services or not. This diagram outlines the key elements of a legally enforceable contract. So what is a legally enforceable contract? Well, it's formed when an offer is made by one party and accepted by another, providing all of these essential elements are met. So, offer and acceptance. An offer must be clear and definite, and not merely a willingness to enter into a negotiation. The offer must be communicated to the other person. An offer must be made to one person or a group of people. It must be a definite promises to be bound, providing the terms are acceptable. A person can withdraw the offer that has been proposed before that offer is accepted. For withdrawal to be effective, the person who has proposed the offer must communicate to the other party that the offer has been withdrawn. Acceptance happens when the party answering the offer agrees to the offer by way of a statement or an act, i.e. by words or conduct. Acceptance must be unequivocal and communicated to the offer, the person, i.e. made the offer. A person is not deemed to have accepted an offer just because they have not expressly rejected it. So this is very much a deal whereby one needs to opt in and not simply be opting out. Intention to create legal relations. Well, the parties must intend to enter into a legally binding contract. Commercial agreements will be seen to include an intention to create legally binding agreement, whilst domestic and social agreements are not. Consideration. Consideration is the price paid for the offer of the other party, although it does not necessarily have to be money. It's something that's given in exchange. So it can be a right, interest, benefit going to the other party, or some loss or detriment to or undertaken by the other party. There is no test as to what constitutes adequate consideration, but it's not sufficient just to take what's been done in the past, what's previously been undertaken. Legal capacity. Each party must have the legal capacity to enter into the contract. These are certain issues and restrictions relating to the following groups. These groups are people with a mental impairment, minors, i.e. somebody below the age of 18, someone who's bankrupt, or prisoners. None of these will be considered as part of this. Consent. So when you are entering into a contract, it must involve free will and a proper understanding of what each party is doing. Consent must be genuine and can be affected by the following factors. Mistake, false statements, duress, and undue influence or unconscientiability, i.e. you need to be conscious when you're signing this contract or entering into this agreement. Legality. Not all contracts will be enforced. Contracts prohibited by state are considered to be void. Contracts for illegal purposes are void. Certainty. The terms of the contract need to be sufficiently certain. What does this mean? Well, if the terms are vague or are effectively just constitute an agreement to agree, then on these terms they have not been precisely established, then the contract will probably not be enforceable. For example, a heads of terms and subject to contract. So, really, what does this mean? Well, if your contracts meet the above requirements, it ensures that your customers understand exactly what they are agreeing to be bound by. So, do your contracts meet these requirements? Let's take a look at some areas that may contribute this. So, are the following examples binding contracts? A used car dealer offers to sell you a car for £3,000. You decide you want to buy the car but insist on the exhaust being replaced. Is this a contract? No, it's not a contract, because the agreement has not been in place. This is a long one. Is this a binding contract? A PR agency offers to market your company on certain terms. You do not actually use the words, "I accept your offer," but you go to the agency's office, you give them the particulars about the company and the product you want to launch. You help the agency prepare a press release, and generally you signal to the agency that they should go ahead with contacting media and start the marketing campaign. So, is this a contract? Well, yes, because you gave them sufficient indication that you guys were entering into a contract. A friend offers to take you to work in their car each day. Is this a contract? Well, no. However, unless you agreed to share petrol and settle up with each other every Friday, this has now formed a contract between you and your friend. If they don't pay you on Friday, they are actually breaking that contract. So beware. Let's move on. Let's talk about the potential impact of social and ethical concerns relating to the sales function. As well as meeting legal and regulatory requirements, organisations should run their operations in a way which are consistent with social and ethical principles, trust and credibility, and in particular, treating customers fairly and with respect are the keys to the success of an organisation. Positive impact, what do we mean by that? Well, behaving as an ethical organisation which responds positively to social concerns can affect an organisation in terms of building sales, attracting investment or future investment, generating recommendations, referrals, testimonials, maintaining loyalty in customers, boosting their revenue, saving money, for example, on marketing to attract new customers, or the time and resources spent dealing with complaints, for example. Negative impact. Well, unethical behaviour and failing to deal with social issues can have a negative influence on the organisation. For example, potentially leaving the organisation in breach of its legal and regulatory obligations. Threat of legal actions, expensive fines, injury to customers, damage to property, bad press, exposure by the media, negative customer reviews, blogs, feedback, questionnaires, loss of customer and contracts, fall in sales, closing down ultimately of the business. So, how can you demonstrate your credibility and trust as an organisation? Let's take a look at some of the ideas. We can do this by these areas. We can become a member of a profession or a regulatory body. We can have best practice standards, adhere to a code of conduct. We can ensure that you have clear, transparent procedures and policies and processes. You can support the customer community, social and corporate responsibility projects and schemes, for example. You can meet external standards, for example, ethical sourcing, fair trade, animal welfare standards, and you can share positive customer experiences via testimonials and case studies. Let's move on. So in order for the organisation to meet its ethical and social requirements and comply with legal and regulatory requirements, it's essential for all personnel to know and understand policies and procedures, including information about how these comply with legal and regulatory requirements. So, the first one, framework for compliance. Within an organisation, there should be a framework for compliance with the requirements we have covered. For example, in standard terms of contracts, operating terms and conditions, product and customer safety, best practice procedures and policies, compliance monitoring and complaints handling, etc. However, it is not enough to simply have those procedures in place. The staff need to know and understand them in order to be able to apply them. So, just having the policy is not good enough. What are we doing to educate our staff in these areas? Policies, procedures and best practices are there for a reason. An organisation should provide a framework to enable its staff to comply with legal and regulatory requirements. It's in their interest to follow them, to protect the individual, the organisation and the customer. The language and nature of the policies and procedures need to be sufficiently clear and unambiguous to enable staff to understand them. The staff need to understand why the procedures exist and understand the legal requirements which have led to those procedures being implemented. The staff need to understand how to implement them correctly. Let's go on to the second area, interface with customers and the public. The staff are acting on behalf of the organisation. They are the point of contact between the customer and the organisation and need to deliver a service which complies with legal, regulatory, ethical and social requirements. Each individual is a PR agent for the organisation and can influence its credibility through their professional manner, knowledge and understanding. The customer may make a judgment about an organisation as a whole based on simply one interaction with a member of staff within that organisation. And then thirdly, accountability. Each individual acts as an agent for and on behalf of the agent. We've said that before. There may be serious legal implications, however, including criminal prosecution and business consequence if the staff fail to meet those requirements. So are your staff aware? Are they aware of the accountability and responsibilities that they have? So we've covered learning outcome 1. Let's take a look at the first task that you have. And this is within the whole of Unit 401. And we'll take a look at Unit 40, learning outcome 1 in a bit more detail. So overall, this is the task. Your sales director is keen to ensure that your organisation has an unrivaled reputation for ethical and law-abiding sales practices. Consequently, you have been asked to research and then compile a 2,000 to 3,000 word report which can be used to inform both management and the sales employees within your organisation on managing responsible selling. The areas that you are required to discuss in your report are below. You have been asked to use examples and references wherever possible. So that's the overall task. This is task learning outcome 1 that we've covered within this seminar. This is all about the legal, regulatory and social requirements pertaining to the sales function. And I've highlighted in red some of the key areas. It needs to outline the fundamental consumer laws that directly affect the way that your organisation carries out sales and marketing. It needs to discuss code of practice. Now, there may be a specific code of practice for your industry. If so, I suggest that you use that one. If you don't have a specific code of practice, use a related industry. And lastly, it needs to discuss why it's necessary for your organisation or any organisation to understand the principles of contract law and for salespeople to understand the principles of contract law. Continuing, you need to explain the meaning of misrepresentation and what are the penalties for misrepresentation. You need to discuss the potential impact to your organisation if salespeople don't understand and abide by these principles. And you need to discuss and advise management within this 2,000 to 3,000 word report on what are the policies and procedures that should be in place to meet the requirements. So that pretty much covers the task learning outcome 1. In our next seminar, we'll be discussing learning outcome 2 and thereafter learning outcome 3. Both of these are much shorter, you'll probably be pleased to know, but really talks about how do you then develop from understanding the principles into actually working with them, monitoring them. So until the next time, have fun.